Steve Derby, and we're going to be talking about prosecuting a lawsuit today. So anyone who's interested in what to do, if you are interested in suing someone or you want to go about collecting a debt or whatever it is, today we're going to try to assist you in teaching you how to go about doing that. So without further ado, we have Steve Derby here. I'm going to ask Steve to tell the audience a little bit about your background and what you do and why you do what you do.
Well, thank you very much for having me here, Amiel. I really appreciate it. So good morning, good afternoon, whenever you're listening to this. My name is Steve Derby. I have been a civil trial attorney for 32 years, almost 33. I am very pleased to be at the Wade Law Group now, and I do civil litigation for them. My background is essentially I have been doing various types of lawsuits, ranging from everything from family law through all sorts of civil cases, some small criminal cases, personal injury, business disputes, real estate transactions over 32 years. And so over that time, I've developed a series of questions that I ask before we start any sort of legal proceeding. And that's pretty much the same no matter what type of legal proceeding it is. But that's why I'm here, is I'm going to try to explain to you, if you think you have a lawsuit, what you might want to do first before you even contact a lawyer.
Okay, sounds great. So let's jump right into it. So there are a lot of people out there who think they may have a lawsuit or want some advice on what they should do with their potential lawsuit. Before they even get to an attorney, what advice can you give them about the things they should do before they even reach out to an attorney?
Well, the first thing I'm going to do, which is probably the bad news, is not every problem that you have, not every wrong can be righted by the law. Many times there are things that are not fair that happen to people that the law can't do anything about. But there's no reason why you shouldn't ask. There's no reason why you shouldn't look into it. And before you contact an attorney, the first thing that you want to do is you want to gather your information. You know your story, but the lawyer doesn't. So you have to make sure that you have your story down, so to speak. It really helps to write it out, to have what we call a narrative. It doesn't have to be long. It just has to be complete. And when you're doing that narrative, certain things may pop up to you, and you ask yourself certain questions like, if I was the lawyer looking at this, what questions would I have? The other thing that lawyers always want to know is, how am I going to prove that in court? Do I have a document? Do I have a witness? The less you have to rely on your own testimony, the better off you are. Documents are perfect because documents don't have any what they call bias. They are what they are, right? They say what they say. A photograph, a contract, an email, a text, even something on social media can be evidence in a court. And that's really the best evidence. The next best evidence is a witness, somebody other than yourself who could say, yes, this is what happened. So the process of gathering all that is really something you want to do. You want to write your narrative and you want to gather your evidence and your documents before you talk to the lawyer, because when you get on the phone or on a Zoom call or whatever with the lawyer, that's what they're going to want to know. They want to know your story, but they also want to know how they can prove it, because they can't help you if they can't prove it in a court of law. So those are sort of the first things that you want to do before you start seeking out legal advice.
That's great advice. And so what about the person who's out there? Because I know there are a lot of people out there who they think they don't have a lot of evidence, right? And what they have is their own story and their word against someone else's word. And I've had a lot of people contact me over the years and they say, I know I don't have a case, I don't have a document, we didn't sign anything. What does it mean if, you have a person out there who believes they have a case, but they don't have documents? Is that the end of the case, or what advice can you give that person about the likelihood of succeeding in a litigation?
All right, well, the first thing I want to say is the law in California enforces oral agreements. It doesn't have to be written down. If you and someone have agreed to something, then you can testify to that agreement, or other people can testify to that agreement, and it is fully enforceable under the law. And I would always encourage you to seek out an attorney with whatever you have, because you don't have to have everything when you start. You have what you have, and then the attorney will either do a demand letter or will file a complaint. But that will be a process of investigation where the lawyer will reach out to your witnesses, for example. They'll check public records. Lawyers have investigators who go out and interview witnesses or get information from public records. Lawyers are very good at gathering information. It's one of the things that we do. And one of my favorite things to do is to investigate, like a little sleuthing, figuring stuff out. But if I can't get everything I need before I file a lawsuit, but I have a good faith belief that I can get it, then I can file the lawsuit and go through the process that they call discovery, where I can sit the person that you are suing down and ask them questions under oath, or I can demand that they produce documents or answer questions in writing, all sorts of things. So just because you don't have all your evidence, you should still contact an attorney to see if that attorney can think of a creative way to get the evidence, or if there's enough there to file a lawsuit and then get the evidence that way.
Great answer. So what about, because I know that there may be a lot of people out there who are thinking, okay, I can file a lawsuit. I don't have to have documentation. It's just my word against the other person's word. I can, say whatever I want, or, whatever within reason, and maybe I can win a lawsuit. For those people, how important is it that they understand what credibility is? And can you talk about the issues that will arise if your lawsuit is based on your testimony only? What are they in for in that situation?
Yeah, credibility is very important. And credibility just means, are you going to be believed? Because someday, if a lawsuit reaches its natural end, which is a jury, 12 or 8 or 9 people, depending upon what court you're in, are going to decide whether they believe you or not. And if they believe you, then you're probably going to do very well in that case. And if they don't believe you, then you're probably not. Even situations where there is some documentation, but they don't believe the person, you can still lose that case. So credibility is something that we have to evaluate right from the beginning. And credibility is not something that is, it is something that is earned. It's earned by a couple of things. One thing it's earned by is always telling your lawyer the truth. The only time a lawyer can't help you is when you don't tell them. Either you don't tell them everything, or you tell them something because you think that's what they want to hear, or because you want them to take your case. And then they take the case and they find out that's not true. Well, that's not going to go well for you or for the lawyer. The best thing to do is be honest. Like Mr. Wade was just saying about being honest and saying, look, I don't know if I have a case. That's perfectly fine. I appreciate hearing that from a client. My antenna gets up a little more when I hear, oh, I got this great case. It's worth $5 million. Let me tell you all about it. Like, well, if you know so much, why do you need a lawyer? And that immediately so it makes us think that, maybe there's something that isn't quite right here. So I'm not saying you have to downplay your case, but be honest. Be honest about the strengths and the weaknesses. The truth is that there is no perfect case. Every case has problems. That's why they need a lawyer. Because if you had the perfect case, you wouldn't need a lawyer. You wouldn't have a case at all, because somebody would have already settled that case with you. The reason that you need a lawyer is because you have what they call problems. You have problems with the case. Maybe you have problems with the law. Maybe you have problems with the facts. But one problem you don't want to have is you don't want to have a problem with your own credibility. The first person you have to convince about your case is your lawyer. So always be honest with your lawyer, good, bad, and indifferent.
Great answer. Okay, so what about the person out there who's thinking, darn, I think I may have a case. I don't have a lot of money. So there's really nothing I can do because I can't see myself paying thousands and thousands of dollars to an attorney to go to trial. For that person, is there anything that they can do or initiate before filing a lawsuit, if you will, that can maybe assist them in getting the recovery that they want?
Yeah, no, every case is a calculation. It's the amount of money you put into it versus what you can get out of it. And there are some cases where there's just not a lot of money that's possible. Or you may be in a financial situation where you just can't afford a lawyer. We represent those folks all the time. I've represented many people who have just told me, look, I've got enough money for you to investigate this case and file what they call a demand letter to an insurance company or to a company that I'm thinking about suing, where I set out in great detail all of the legal principles. But I do the same work that I do when I file a complaint. It's the facts are in there, the evidence is in there, and the law is in there, and I tell them what I want. And then many times I will get a response. Now, with insurance companies, this tends to work better than private companies. And it doesn't really work well with an individual because usually what happens is they go to a lawyer and the lawyer says, well, why don't you wait and see if they sue you? But if you're dealing with an insurance company, for example, which is where this happens most often, insurance companies exist for one reason, which is to take in premiums and pay out claims. That's what they do. So they are not troubled or offended by your demand letter. They appreciate it. They want to negotiate the case. Now, if there's a case to be negotiated, that can be handled fairly quickly and fairly inexpensively compared to a lawsuit, which, as Mr. Wade said, is very, very expensive. And so you don't want to get involved with that if you don't have, one, enough money to pay for it, and two, the possibility of a significant recovery, or some types of cases actually let you get your attorney's fees back. And those are specialty kind of cases. But for the typical case, let's say you were involved in an auto accident, let's say you fell in somebody's home, let's say you were in a fire, you were a tenant in a building that was burned and you lost all your stuff. Those kinds of things don't have the ability for you to get your money back, for the lawyer's fees. But you can file a demand letter and the lawyer can negotiate the best deal for you without filing a lawsuit. So just because you don't have a lot of money doesn't mean that a lawyer can't help you.
Okay, so let's talk about the lawsuit itself. So the lawsuit starts, as you know, with the drafting of a document that lays out all the claims of the person who's trying to recover money. Mm-hmm. And, there are a lot of approaches to doing the complaint. There are obviously some attorneys who may quickly draft a complaint and not, think about all the different causes of action. We can talk about what that is. And there are others who are more detailed and take a different approach to drafting and filing a lawsuit. When you're tasked with drafting a complaint, a lawsuit, what types of things do you consider and how do you go about, drafting it and deciding what goes in it?
Okay, well, the facts. The facts go in. So usually when you file a complaint, the first section after the legalese about why you picked this particular court, the next thing comes is the facts. Who are the people? Who's the plaintiff? Who are the defendants? What are the facts that bring this case to the court? Did you get in a car accident? Are you having a business dispute? Did you get cheated in a real estate transaction? Whatever it might be, those facts are laid out first in a section that I usually call the facts, facts of the complaint or facts common to all causes of action, which are the legal theories under which you are able to recover. And there are many legal theories. But before you start drafting a complaint, I always like to ask, the first question is, what does my client want? Does my client want money? If it's a business dispute, does my client want to be out of the business? Does my client want to create leverage to buy their partners that they're not getting along with out? There are many things. So the first thing that I always try to figure out before I even sit down to consider legal theories is I've got the facts. Now what does my client want? Based on what they want, that's what I determine. Because there's some kinds of legal claims that are designed just to get you money. There are other kinds that are designed to create change. A judge may decide that a company can no longer function. A judge may decide that you own a company that somebody has kicked you out of. In a real estate transaction, you might get to give the property back. There are all sorts of things that are possible. And before you even start drafting the complaint, you have to think about what your client wants. And then after that, you sit down and you think about all of the different legal theories that will get you what you want. Kind of like when you're doing Google Maps, right? There's different ways to the same place. And when you're going to the same place, any road will get you there. So all those different roads need to be explored because you never know where you're going to run into a problem in a lawsuit. Maybe you have problems with what they call a statute of limitations, a deadline by which you had to have done something to enforce your rights. Or maybe there's some legal reason that you can't do what you want to do. So it's good to have as many roads to your destination, which is what you choose as the client. If it's possible, you choose what the lawyer does. And then the lawyer starts to think about all the legal theories. That's sort of the second step, is to start working on the legal theories.
Great. Okay, so what about the person who's out there and they want to file a lawsuit, and it so happens that they live in a place that's different from the person they want to sue? So for that person, let's hypothetically say the person who wants to sue lives in San Diego, and the person that they want to sue lives in Sacramento. What can you tell that person about where the lawsuit may need to be filed, depending on certain circumstances?
All right, so there's a whole bunch of laws about where a lawsuit has to be filed. Well, you can always file it where the person that you're suing lives. That's always the case. But there are many times you don't have to do that. For example, if you make an agreement, you have an oral agreement or a written agreement, you can sue where that agreement was made or was to be performed. So let's say, in Mr. Wade's hypothetical, let's say that this person came down from Sacramento, met you at your house, and you signed a contract, and you were going to work from home, and this is where you were going to do your work. Well, you can sue them in San Diego because the contract was made here, and because it was going to be performed here, meaning you were going to do your part here. So those are other situations. Other things is if it involves real estate. Where the real estate is where you usually bring the lawsuit. There's some exceptions, but usually. So let's say that you and this person in Sacramento decide you wanted to buy a property in Los Angeles. Well, guess what? You can't sue in San Diego, you can't sue in Sacramento. You've got to sue in Los Angeles because that's where the property is. So there's a lot to consider depending upon the type of case. But just because you and the person you're suing live in different places, even different states, even different countries, does not mean that you automatically have to go where they are.
Great answer. So for you guys out there who are thinking about filing a lawsuit on your own, you may want to get some advice on as to whether or not you're filing it in the right location, because as Mr. Derby is saying, that's very important. So, okay, so now we've talked about the complaint and what to consider when drafting it. So let's talk about what happens, what the next phase of litigation is after you have drafted the lawsuit. What happens next?
All right. So after you've drafted the lawsuit, of course, you give it to your client to review, make sure the facts are right. Because someday the client might be sitting there in a deposition, sworn to tell the truth, and be asked about the complaint facts. Is this true? What proof do you have of that? And if your facts that you filed in the complaint are not the same as the client says, no, that's not what happened, that is, one, again, bad for credibility. Bad for your lawyer, too, but bad for credibility for you. Because now you filed a lawsuit with a fact that isn't a fact. And that is the first step to not having a jury believe you. So first thing is send the completed complaint. And I always tell my clients, don't worry about anything after paragraph, whatever. When I start my causes of action, there's lots of legalese. I use words like, all sorts of weird legal words like negligence and alter ego and in rem jurisdiction. There may be all this crazy stuff in there that you don't have to worry about because that's why you hired a lawyer. But the facts, that's something that I need you to check over. Once that's done, then the complaint is filed in the court, either a state or federal court, wherever they call that venue, in the county in which it is. And in some counties, like huge counties, like Los Angeles and San Diego, for example, there are different divisions of the court. Like in Los Angeles, if you may be suing in the downtown courts, or you may be way the heck out there in Thousand Oaks, or you might be all the way east. You could be all sorts of places. And in San Diego, it's kind of divided between South County, Central, and North County. So depending upon what particular court you're in, that's where you file the lawsuit. So the next step is you file this lawsuit. It comes back with a stamp on it saying, okay, now you have a lawsuit. And you pay some money, and the case gets started.
Great. Okay. So we've spoken about how a lawsuit can be resolved, before it gets started. If you send a demand letter, you may be fortunate, and you may end up settling the case before the case gets started. Here we are, the lawsuit has started. We've drafted the complaint. We served it on a defendant. Is this another potential occasion in which the case could settle? And if so, why?
Well, for a couple of reasons. One is, remember I said that sometimes what will happen, especially with individuals or businesses, is they'll go seek legal advice. And the legal advice will be, well, wait till they sue you. Then you know they're serious. Then you know that this person didn't just hire a lawyer to write a letter and then nothing was ever going to happen. Well, now something's happened. And the other reason is because now they receive what's called a summons. They get served, maybe at their home, maybe at their business. They get served with this thing that says, you have to respond to this complaint within 30 days. Otherwise, the court will assume that you agree with everything, and you'll get what's called a default against you, which is like you went to trial and lost. So they have to deal with all these things now. They like you, have to have legal counsel, have to have advice, and they have to pay for that advice. So that's an opportunity for the case to settle. Because if they go back to that same lawyer who says now, well, okay, I guess I was wrong, they are going to sue you, and here's now what you're facing. Here's how much money I need in what they call a retainer. Here's your chances of success, and here's what you're likely to be facing. And that is, as Mr. Wade says, a perfect opportunity for a settlement to occur. Many times, we will file a legal action if we are the plaintiff, and we'll get a telephone call from a lawyer saying, hey, I've just been hired, can we talk about this case? So that's another opportunity to settle. Or flip it the other way, you are the person sued, and you come to me and say, I need defense in this. I'm very likely to reach out to the lawyer if I think there is a good case here that you should think about settling, because it's going to cost you a lot of money. So that's another opportunity. I think that's probably most of the situations when you'd see a lawsuit itself creating the opportunity for settlement.
Okay, great. And the reason we're talking about this is because I know there are a lot of you out there who are concerned about finances, and you're thinking, gosh, if I start a lawsuit, I'm going to be in a lawsuit for a very long time. So as we go through how to prosecute a lawsuit, I also want to let you know where possibly you may be able to get out of the lawsuit via a settlement. And that's what we're going to be talking about as we go through this timeline. So after the defendant is served, and let's say we're representing someone and they are unfortunate up to that point with respect to trying to get the case resolved, what happens next? And when is the next point that you're looking to see if the case could possibly settle?
Okay, so the next thing that happens is there is a response to the lawsuit. It's usually what they call an answer. And except in certain situations, the answer is just, I deny everything. I deny everything, and I have all these reasons why I don't owe you anything. Or what you want, you can't have, whatever the situation might be. That's the usual kind of thing. Sometimes you get another kind of response, which is a challenge to your complaint, that it is somehow not legally appropriate. And so you have this next phase, which is either happens very quickly or could take a very long time. If it's an answer, then we move immediately to the next phase, which is called discovery. But let me just put that aside for a minute and say, let's say that a lawyer reaches out to your lawyer and says, your complaint is not legally valid. There's some problem with it, and I'm going to challenge it in court. So before you get any discovery, before you get any chance to ask my client one single question, you're going to first have to prove to a judge that you have a valid complaint. And so that challenge can take quite a bit of time and can be quite expensive. Many times, because there's a process, what lawyers call meet and confer, the two lawyers have to talk before any more documents are filed. And many times, the plaintiff's lawyer will decide, even if they don't think some of the arguments are correct that the defense lawyer is making, they're better off just fixing the complaint in some sort of way. So they file what's called an amended complaint. And that may once again create the opportunity for an answer, or it may create an opportunity for settlement. Because sometimes what the defense lawyer is trying to do is, well, we used to call it testing your mettle, which is they want to find out if you are really in this for the long haul, you, the plaintiff's lawyer, and if your client is prepared for this to be a very long fight. Because many times when you show that you are ready for a long fight, you suddenly don't have one, because everything that you're paying for, they're paying for. So at some point, both of you get tired of paying money, and the case can settle at that juncture as well. Once you get past these challenges, and assuming the case doesn't settle again, then you move on to the next phase, which is called case management and discovery.
Great. Okay. So when we talk about discovery, because in my view, I think if we were to talk about the segments of litigation, I believe you have, pre-litigation where, as Mr. Derby indicated, you're supposed to get all your stuff ready and documentation, witnesses, evidence, and all that. Then we have the complaint in which the attorney is drafting, right? Then we have, after that, we have the discovery phases, which is what we're going to talk about next. And then there's usually some form of mediation that is part of the lawsuit. Then trial, then a resolution if it goes the distance, right? So now we're kind of in an area where we're going to talk about phase 3, the discovery phase. And for those who don't know what that is, can you tell them what that phase is all about?
Sure. So discovery is discovering. When you say you're discovering something, you're finding something out. So that's what we call discovery. And I mentioned, remember, back when we were talking about the first call with a lawyer, if you don't have all of your evidence, well, that's when your lawyer gets the evidence that you need from the other party, or maybe from a third party. Maybe neither one of you knows the answer to the question or can prove it in court, but somebody else can. Typical example would be something like medical records from a medical doctor, if the case involves some medical issue, or perhaps some sort of records from an insurance company, or some sort of records from a business that's not connected with the lawsuit, but was somehow involved in the transaction. These types of things is called discovery. It includes questions, it includes requests for documents, and it includes something very specialized called requests for admissions. Now, requests for admissions aren't really discovery. They're designed to eliminate an issue. Like, let's say you want to establish that the event that you're suing happened on April 14th, 2022. So you ask them, you say, admit to me that on April 14th, 2022, this happened. Because remember, their answer was, I deny everything. So everything has to be proven in court. So you can get some of those things taken care of. But just to ask questions or to get documents, that's another way that you gather evidence. And then the last thing that you usually do is you take depositions. Usually you want to take the deposition of the person that you've sued. And you also want to take the deposition of anybody that comes up in their answers. If you ask them, well, how do you know that this happened? Who are your witnesses? And they say, well, Mr. Wade's my witness. Okay, well, I want to take Mr. Wade's deposition because they say he's a witness, so I want to know what he has to say. So that process of discovery can be quite long, but it's very important because, once again, if you get to the next phase or you get to the ultimate phase of having to prove your case in court, you need your evidence, and that's really important to have.
Okay, so just so they understand, if you bring a lawsuit, you're going to have an opportunity to tell your story because the other side is going to want to talk to you and they're going to ask you questions about your evidence. So when Mr. Derby is talking about a deposition, can you just kind of tell them like usually where that takes place and what that is all about so they know that that's something that they're going to be in for if they do bring a lawsuit?
Oh, sure. So a deposition is usually not in court, but it is done in a lawyer's office or in a conference room somewhere. The most important person is called a court reporter. That court reporter is certified by the court, and they use a little machine that's kind of like a typewriter, but not like a typewriter, and they take down everything that is said. So in a typical deposition, you will go with your lawyer to the other lawyer's office or to this court reporter's office, and the first thing they'll do is they swear you to tell the truth. And that oath is the same as you take when you go into court. So everything you say there is under oath, and it can be used in court against you or for you, depending upon your situation. And so the lawyer then asks you a series of questions. They start with simple stuff, like, what's your name? Where do you live? What's your education? Are you married? Do you have children? Those sorts of things. And then they get into the facts of the lawsuit. Because the reason the lawyer wants to take your deposition is they want to find out your story. They want to know why it is you've sued their client. And it's not because they're curious about it. It's because they're trying to pin you down. They're trying to find out what evidence you have. Because once they know all the evidence you have, they can start to look for something you don't have that you need in order to win the case. And then they can build their defense around that. So a deposition is an opportunity for you to tell your story, but it is question and answer. The lawyer is not there because they're interested in hearing your story. And you never want to, we haven't talked too much about how depositions go or my advice to my clients being deposed. But a good thing to remember is an analogy my first boss taught me, which is, if I ask you if you have a watch on, don't tell me what time it is. Just say, yes, I have a watch. and make them ask the next question. Because lawyers, information to us is our stock and trade. It is what we trade in. The lawyer with the most information usually wins. And one of the ways that I get information out of my opponents is I ask them questions. And sometimes you go to a deposition and the person just starts talking. I say something simple like, tell us your name, and then I get a one-page answer in the transcript of what was said. So you want to be very careful not to give away too much information, but it is your opportunity to tell your story under oath. Like I said, it typically happens in the lawyer's office. The people there are the court reporter that I mentioned, your lawyer, you, and the other lawyer. Now, sometimes the person you sued can be there, or if they are represented by an insurance company, sometimes the insurance company will send someone. But for the most part, it's a small group of people. And that small group of people, they sit there and you're asked questions for as long as it is that they want to ask you questions. There is a limit, but it's a very long time. So that's kind of the nuts and bolts of a deposition. If you wanted to talk more about that, that would be a much longer conversation. But just so you understand what it is when I say a deposition.
Great. So today we're talking litigation. We're talking about prosecuting a case, and we're talking about the first three phases of litigation, which are preparing before you start your lawsuit, drafting a complaint, and then engaging in discovery. This is part one of actually a part two segment that myself and Mr. Derby are going to do. In part two, which we're going to air at a later time, we're going to be talking about phase 4, which is mediation, which is the very important part of a lawsuit. And then we're going to talk about the trial process. But for today, we're wrapping up the first three segments. And we want to conclude by just having Mr. Derby just generalize. Discovery is where you go about gathering evidence to attack your case, improving all your evidence. Is there anything else you want to add about that before we end this segment?
No, it's just a very important time in the case because we haven't talked about the ways that a complaint can be challenged after it's been answered.